Hello and welcome to NewsClick. One of the key takeaways from President Obama's visit to India this week has been the various steps taken by the government of India to address the concerns of the Americans over our civil nuclear liability regime. The US has been aggressively lobbying against our liability regime that could hold US-based suppliers liable in the event any parts supplied by them are faulty and cause a nuclear accident in India. While details of this deal are yet to be announced, reports indicate that the Indian government has agreed to create a pool of 1,500 crores and in the process cap the liability of non-Indian suppliers. This seemingly indicates a step away from India's previous stance on the issue, under which our taxpayers would not bear the complete financial burden of any nuclear accident should it occur. To discuss the issue, we have with us Prabir Purkayastha from the Delhi Science Forum and the All India People's Science Network. Hi Prabir, welcome to NewsClick.
Good to be here.
Now, what was the crux of the nuclear liability regime as initially put in place by Parliament, and why was this problematic for foreign suppliers? Is this regime that we had put in place very different to the international standards on the issue?
If you look at the nuclear supplier liability issue, originally what came up was a no liability regime. And this started in the United States, which felt that the liability which the insurance companies would have to bear would be too high, and therefore there was basically an act in the Congress which decided that liabilities would be pooled, the government would underwrite those liabilities and so on. Net result was that there is a insurance liability pool which has been built up by the operators. Effectively, suppliers have no liability. This is something which has been followed in different countries. The understanding being a nuclear accident is so huge that if a supplier has to take liability for it, there will be no nuclear industry. This is the original issue. Now, we have come a long way from that. It's 50 years down the line. The same arguments do not hold good for any other hazardous industry except the nuclear industry. Only in the nuclear industry you have a supplier's claim that there should be a no liability regime for whatever they supply. So, this is a backdrop within which the nuclear liability accident liabilities have to be seen. Now, in India, we had decided very clearly that there will be a liability of only 300 million SDRs for the operator. Some of us had argued that this is too low a liability, that actually it should be higher because in nuclear accident, the costs are much higher. Therefore, this is too low a liability on the operators. But leaving that aside, because in India right now the operators are also government entities. So, essentially the government and the operators bear the responsibility. Any cost which is higher than $300 million would effectively, or 300 million SDRs, would effectively be carried by the government of India. That's the understanding with which it is made. And there are two provisions of liability, as it were. One provision which says essentially the liability of the operator can be channeled finally as a right to recourse to the suppliers. So, the operators have a right to recourse from the suppliers if they have supplied defective equipment. That was basically the argument. Since the operators' liability is capped at 300 million SDRs, there is automatically a 1,500 crore cap virtually for all the suppliers' liabilities also.
Because they can only claim how much?
They can only claim up to what the operators have paid out. So, that was anyway there. So, the cap is no longer or never an issue. The essential issue is suppliers' refusal to carry any liability, and in this case what the government of India has done by carrying 750 crores themselves and 750 crores by the public sector insurance companies, they have effectively said that all the liability of the suppliers will be carried by Indian insurance companies or the government of India, effectively making it a no liability regime for nuclear suppliers. Now, the question is, this is the only industry in the whole world that enjoys this kind of privilege, and this is what a number of people have said. This is actually what makes the nuclear industry even viable, because if they actually had to pay for the relevant insurance premiums which other hazardous industries pay, I do not think the nuclear industry would be economically viable.
An unwarranted subsidy to the nuclear industry,
essentially, it's a subsidy to nuclear industry. It made sense to do it at a time when nuclear industry was a nascent industry. Essentially we did not know what would be the extent to which it would be able to supply power. Today, post Fukushima, nuclear industry's costs have also become pretty high. They have roughly 5 times the capital cost a coal-fired plant today has. So, given that kind of cost, actually solar thermal, which in Gujarat or Rajasthan is easy to make, would be viable. So, I do not see today giving this extra cushion of an insurance benefit to only nuclear industry making sense economically. Forget the
from a
other
cost-benefit analysis perspective. Now, the liability regime we had here was set up after much discussion and debate and some amount of cross-party consensus on this issue. What is the fact that the executive seems to have moved ahead on this without consulting Parliament in terms of diluting the law? What does it mean? And specifically, why is India so eager to purchase nuclear equipment from the United States itself? I mean, given that the nuclear industry is essentially dying slowly in the West, shouldn't we be in a better position to bargain as far as importing equipment is concerned?
Clearly, the nuclear industry is dying in the West, particularly the United States. I don't think they've supplied a nuclear reactor in the United States for more than 35 years. If you look at the age of the people involved in the nuclear industry today, who are still alive and functioning in the United States, they are over 60. So you already have a virtually dying nuclear industry. Therefore, India's offer to buy 10,000 megawatts worth of reactors makes so so important for the US nuclear industry, and that's why it has been number one on the US list, because that's the only way they see themselves of reviving the nuclear industry, if at all, and then being able to sell it to others. So that's one part of it. One part of the nuclear liability is also what is called the Section 46 of the Nuclear Liability Act, where there is what it says is that all other laws would apply. Now, all these other laws also has been a problem for the United States, and we seem to have given them some assurance that no tort claims arising out of any other consideration would be accepted, and will interpret Section 46 with a memorandum of law. I don't know what it really means. Seems to be something which Indian legal jurisdiction should not accept, because an act of parliament is the highest body. Yeah. So, I mean, after that it cannot be diluted by the executive through an interpretation. So, I think there is a problem over here which we have to sort out, okay, how this is going to be done, but it seems some assurance has also been given on that count.
Now, given that our government, I mean, the issue of whether we should pursue nuclear energy at the cost of other forms of energy is a separate issue. But once our government has made the decision that we will go down the nuclear route, isn't it fair then for the government to actually bear the risks of such an exercise?
Well, it's clear that the government bears the major part of the risk, because if there is an accident, there is no question the damage will not be limited to 300 million SDRs. It's going to be much higher than that. Even the Bhopal disaster has a damage which is far higher than the 300 million SDRs we are talking about. In fact, it is more than the 400 million, roughly $400 million that was the damage that the Supreme Court finally accepted. And we know now that's a gross underestimate of the damage that took place. If you have a nuclear disaster of the kind Fukushima has had, the disaster runs into billions of dollars. And it
estimated at 20 billion apparently.
20 billion, and that also, if you see what the costs are going to be in the future, we don't really know, because we have still failed to address the serious problems of leaking radioactive water in Fukushima. So even today, we have not been able to solve that problem. It is leaking into the groundwater, it's leaking into the sea as of today. So these are costs which can only escalate, it's not going to go down. So we are talking of billions of dollars of damage that can take place of a nuclear accident. And look, we are going to build 6 reactors in the same place. That's 10,000 megawatts in Gujarat. Now, 6 reactors after the Fukushima disaster is also something we should really think, because what it means, if one reactor has a meltdown or is damaged, it affects the functioning of the next 5 reactors which are there. So these are very, very difficult decisions. So I do agree that the government should take some responsibilities. That's never been in question, because the government has already taken that responsibility by capping the operator's liability. What we are talking is having no liability at all on the suppliers. For companies which are going to supply, as I said, billions of dollars of reactors, which Westinghouse is apparently going to do if this 10,000 megawatt deal goes through, then we are really talking of huge gains to the suppliers and no willingness to take even marginal cost of the liability, which is what an insurance premium for 300 million SDRs would be.
Exactly. That's actually my final question. In terms of, now that it appears we have agreed to dilute our regime to some extent, what is the positives that India gets out of this? I mean, whether you look at the specific issue of nuclear energy, or is it a trade-off with other aspects in some other field?
See, the concession that we have made on this is without a quid pro quo right now. India had needed only access to nuclear fuel. It had nuclear technology to build reactors. It could have built its own version of third generation, fourth generation reactors. So those were not really the issues for India. The real issue for India was nuclear fuel, which it already has. Access to nuclear fuel is already there, and that's been only the limited benefit of the new India-US nuclear deal. It didn't need anything further. Now, looking at this agreement that we have made, US is not committed to giving anything else, like what it committed earlier, give access to technology, etc. None of these things are on the offer right now. The ability to reprocess, all these things will need further acts of US Congress. So given this, our limited benefit, what was the access to nuclear fuel, did not need this deal any further.
Well, that's all the time we have today on NewsClick. Do join us again for another episode.